Hello, welcome everyone. Thank you so much for joining us for today's webinar hosted by KCAB International LA office. My name is Hyun Lim. I'm in charge of KCAB International LA office. I will be moderator for this webinar. This webinar is co-hosted by Consul General of the Republic of Korea in LA, California, and hosting law firms are Brisbois in LA and Fort Lauderdale, Florida, Kim Lee in Seoul, and David Hirson and partners in Costa Mesa, Orange County. Today, we are going to discuss essential legal topics for Korean corporations and U.S. corporations dealing with international transactions so that the corporations can prepare possible legal matters. This webinar will be very practical and helpful for companies covering cross-border issues. The topics will be presented by Korean and U.S. attorneys in English. All of our panelists have extensive and professional experiences in their own field. Without further ado, let's go ahead and start it. I'm going to introduce our special guest. Mr. Kyung Park is a newly appointed Consul General of the Republic of Korea in LA. And now I'm going to turn the time over to Consul General for the welcome remarks. It will be in Korean. Consul Sungsoo will introduce Consul General.
예, 안녕하십니까. 저는 LA 총영사관의 손성수 영사라고 하고요. 저는 총영사관에서 기업 지원 업무를 담당하고 있습니다. 그래서 오늘 아주 짧은 1시간 동안에 5분의 우리 강사님들이 법률 문제, 어려운 거를 많이 이렇게 좋은 말씀 해주실 텐데요. 언제라도 저희 영사관에 연락을 주시면 저희가 또 필요한 부분을 도와드리고 오늘 그 세미나 영상과 발표 자료도 저희 총영사관 게시판에 올리도록 하겠습니다. 그러면은 우리 박경재 총영사님의 인사 말씀을 듣겠습니다.
예, 안녕하십니까. 박경재입니다. 오늘 바쁘신데 이렇게 미국에서, 한국에서 많은 분들이 참석을 해주셔서 고맙습니다. 이번 리걸 웨비나는 코로나19 시대에 미국 진출을 계획하고 있는 한국 기업인들에게 아주 유용한 정보를 전달할 수 있는 좋은 기회라고 생각을 합니다. 오늘 좋은 세미나를 만들어 주신 대한상사주전의 임수연 사무총장님과 이선아 LA 사무소장님, 그리고 오늘 유익한 강의를 해주실 루이스 브리스보아스의 스칼릿 대표님, 수진 이시코프 변호사님, BKA 로펌의 김흥중 대표님, 데이비드 헐슨 앤 파트너즈의 에블린 한 변호사님께도 감사를 드립니다. 현재 미국은 코로나19가 지속되는 상황에서도 기업과 정부의 노력에 힘입어 경제 회복의 속도를 내고 있으며 새로운 시장을 개척하려는 많은 한국 기업들도 미국 진출에 지속적으로 도전을 하고 있습니다. 지금 미국 진출을 희망하는 기업들이 가장 어려워하는 부분이 아마 법인 설립, 고용 등 법률 이슈라고 알고 있습니다. 이번 세미나는 법률 이슈 등 각 분야의 최고 전문가들을 모셨기 때문에 큰 도움이 될 거라고 생각을 합니다. 특히 서로 다른 나라의 기업 사이에서 법적 분쟁이 있을 때 국제소송보다 시간과 비용 면에서 훨씬 효율적인 국제상사 제도에 대해서 세계적으로 높이 평가받고 있는 대한상사중재원이 직접 설명을 해드리기 때문에 아주 유용한 정보가 되리라고 생각을 합니다. 앞으로도 저희 총영사관에서 기업에 도움이 되는 다양한 주제의 온라인 세미나를 적극 추진할 예정입니다. 혹시 필요한 분야나 도움을 드릴 게 있으면 많은 의견을 주시기 바랍니다. Good afternoon. My name is Kyung Park, Consul General of the Republic of Korea in LA. Thank you very much for joining this legal webinar. I'd like to extend my warm greetings to all of the participants. In the midst of a pandemic, many Korean businesses continue to expand its business into the U.S. In this regard, I'm confident that this webinar will be a good opportunity to get valuable information and in-depth advice on legal issues. I have heard that the most challenging aspect of entering the U.S. market is dealing with the legal issues surrounding setting up U.S. corporate employment and so forth. As we have brought to you the most prominent legal experts in this field, this webinar will be tremendously helpful. Taking this opportunity, I would like to express my sincere gratitude to KCAB and all presenters for their efforts to arrange this wonderful event. In these tough economic times, it's never been more important to help each other. I extend my best wishes for your future endeavor. Thank you very much.
Thank you, Consul General. Now I'm going to introduce Hyun Lim. Soo is Secretary General at KCAB International in Seoul. Before joining KCAB, she was a partner at Beck, Kim, and Lee in Seoul, and she specializes in international arbitration law. She's going to present introduction of KCAB International and how to use international arbitration effectively for international corporations. Soo?
Hi, 안녕하세요. Thanks for having me in this webinar. It's great to see so many people sign up, and it's great to see the high level of interest in the topics that will be presented today. I'm also very pleased that we have a fantastic lineup of speakers for today's webinar. We did a short test run earlier today, and I think the content that the speakers have prepared for you are really the key points that you need to know in order to conduct international business and for successful investment into the US. So while the other speakers here were invited to join because of their expert knowledge, I'm here to represent KCAB, the co-host of the seminar. And as such, I get to do a short plug for the KCAB. The good news is that my presentation will deal with the easy stuff and will be brief. The next speakers will take you through the more difficult headaches and the related legal issues. So I'm here to give you a quick introduction on KCAB International, the international arm of the Korean Commercial Arbitration Board, hence the acronym KCAB, and why it may be the better option for many business people thinking of doing international business involving Korea. Yes, we are on the correct slide. First, a word on KCAB, its origins and its developments. KCAB was established in 1966 and it was founded under the auspices of the Arbitration Act of Korea. The history of KCAB is interesting because back in the 1960s, that is when Korea started exporting its products. Back then, it was mostly textiles, shoes, plastics, the very basic stuff. And unfortunately, back then, the products weren't that great quality. So it happened in the 1960s, 50s, and 60s that a lot of the international buyers actually came over to the consulates and the embassies of Korea, knocking the doors, asking them for a dispute resolution or to lodge their complaints about the products. And that built up into the need of having a reliable, very efficient, and very business-minded dispute resolution center. And with the help of, I believe, the American Chamber of Commerce in Korea, the KCAB was established. Now, fast forward into the future, and if you reach 1999, not long after the Asian financial crisis, Korea decided to modernize its arbitration regime. It was one of the first countries to accept the UNCITRAL model law. And in fact, as of current date, it is probably one of the largest and more active international arbitration markets in Northeast Asia. And as we entered 2007, the need for a separate international arbitration rules was felt among the institution, and the international rules were first introduced. I'll let the other part of the history be part of the slide. And next slide, please. Next slide, please. Thank you. So in order to meet the demands of international users, KCAB International was established 2 years ago. It's an independent division within the KCAB, but it moves on its own rules and its own protocol. Its functions and activities are mostly case administration for arbitrations that are filed under the KCAB International rules. And we do a lot of outreach initiatives, which means we do a lot of conferences, webinars, seminars, roadshows, And we also have very good relationship with the other institutions around the world. Next slide, please. Right, so who runs the show? That is, who runs KCAB? So the board is probably the highest level of decision maker, but I've just mentioned them out of courtesy because they are very much a very high level supervisory board. They just make sure the KCAB is doing arbitration and not arbitration or dispute resolution as opposed to other things. The key actors of KCAB is the Secretariat, which oversees the case management. It revises the rules, and it makes sure that each individual cases are conducted in a way that meets the international standards of arbitration. There's also the IAC, which is the acronym for the International Arbitration Committee, which is an advisory board composed of 20 of the most prominent international arbitration practitioners at this time. 9 of them are Korean, 11 of them are people based in Singapore, Hong Kong, England, US, and various parts of the world. Of course, either the board, secretariat, and the IAC, they do not actually rule on the specific merits of the case. They will, it's the panel of arbitrators or the arbitrators from that panel that decide on the case. The panel of arbitrators are very diverse, and I think this is a strength of KCAB. Just because it is based in Korea and has a lot of Korean parties, it does not mean that the procedures are conducted in Korean. I mean, you may conduct them in Korean, but it's very international. The arbitrators are mostly outside of Korea, and the actual appointments of arbitrators are based on the parties' needs, nationalities, and interests. But at the same time, ensuring that the arbitrators are experts in the field, and also that they're neutral and they have a high quality of adjudication skills. Next slide, please. So how busy is KCAB? We have the case statistics of the last 8-9 years. And I'm happy to say that we are seeing a consistent rise in the number of cases, in particularly the international cases. If you compare the numbers of cases to the local state courts or even the Seoul Central District Court, the numbers may not seem high. But if you consider that even the busiest international arbitration centers around the world do not have more than 1,000 cases a year, and in fact, Korea, KCAB ranks number 5 in terms of the caseload per year among the international institutions. KCAB can be considered to be pretty busy, and with the 50 years of experience and more than 7,000 cases as our track record, KCAB is known to be a very experienced, neutral, competent, and well-established name in the field of international arbitration. Next slide, please. Right, nationality of parties. The KCAB deals with cases that predominantly involve Korean businesses, but it is not exclusively only for Korean parties. Many of the cases have at least one Korean party on one side, but we are seeing a consistent rise of cases that do not involve Korean parties. For example, we have 5 to 6 cases that involve only Hong Kongese or English or Singaporean cases. Of course, there are some Korean interests behind the business deals, but still in terms of the corporations, the nationalities are very diverse, as you can see on the slide. Next slide, please. And finally, if you come to the KCAB, there is an added level of convenience and efficiency, especially if you have close ties to Korea. There is a separate hearing facility, a dedicated hearing facility that only deals with arbitration hearings called the Seoul IDRC. The administrative costs of filing your case at KCAB is relatively reasonable compared to other international cases, other international arbitrations. And the arbitrators' fees are also reasonable, of course, to the extent that the arbitrators are properly compensated in order to do quality job, but at the same time, it has a price competitive edge compared to other institutions. You do not necessarily have to come to Korea in order to do a venue. You can always choose another venue for your hearing. And in fact, you don't even have to leave your city because there is a full-fledged virtual hearing setting that the Seoul IDRC has invested for the last few years and which has accelerated during the last few months due to the corona pandemic. So if you have any ties to Korea, love to come to Korea, please come use the facility for the KCAB cases or any other cases as well. The difference is that if you come to the Seoul IDRC for the KCAB cases, the use of the facility is actually free. You can use the nice looking offices that you see on the slide for free. And you also can conduct seminars, depositions, or any other events that you need to if you come to Seoul. And of course, virtual remote hearings are also an option. So moving on to the next slide, which is actually the last slide I have. I just want to say thank you for hearing. This is all I have for today, and that I hope you enjoy the other speakers and the expert knowledge that they are here to impart. Thank you.
Okay, thank you for the nice presentation. Now, I'm going to introduce Scott Lee and Hongjun Kim. They are legal experts in cross-border issues. Scott Lee is partner at Brisbois in LA, and he specializes in corporate law and commercial litigation.
Well, thank you, Mr. Kim. I want to thank KCAB for putting on the seminar. I want to thank the Consul General's office, also our colleagues at David Hirson and Partners. It's been a real pleasure to join everybody in this webinar. My name is Scott Lee. I'm a partner at Lewis Brisbois. I'm here in LA. So let's go right into the enforceability of arbitration clause in California. In the U.S., there's two set of laws. We have federal laws, we have state laws, and you know where I live in California, there are two set of laws that affect arbitration under CAA, California Arbitration Act, and the FAA, which is Federal Arbitration Act. Arbitration generally is considered a cheaper and faster ways of resolving issues. I think Mr. Kim had mentioned about the fees for arbitration. The unique thing in California is that if you have an employer-employee arbitration is paid for 100% by the employer. So that's kind of unique to California. Next slide, please. Yeah, I want to kind of compare. I know we've been talking about arbitration pros and cons. So I want to set out a chart that shows pros, positive aspects of going to arbitration versus cons, which is the negative side. So just for the for the pros, I mean, I think we talked about it. One of the things that avoids hostility. Usually, it's cheaper than litigation, and where we're at, again, Los Angeles, cost of litigation is going up and up and up. Usually, for a real commercial litigation matter, we're looking at attorney's fees anywhere between $50,000 to $100,000 easily, if not more. So in comparison to arbitration, it's going to be a fraction of that. So usually it's a cheaper than litigation. It's usually faster than litigation. It will use arbitration usually take less than a year to complete, whereas litigation can drag on for multiple number of years. It's very flexible because it's not rigid rules like in the courtroom. There are very flexible rules that people can utilize. And then there's simplified rules of evidence and procedure. That this is very important because great majority of costs in U.S. litigation deals with discovery, which is document discovery, requests, exchanges, and also depositions. There are limited discovery conducted in arbitration, but not as extensive as litigation. So that's one of the shortcuts you could do. And then lastly, it's very important, a large company or small, it's not public. So anytime you file a lawsuit, it's a public information. Anyone can go and get copies of pleadings for the most part. But this is very private. No one's gonna know, especially if you have some embarrassing litigation. You don't want to be known to the public. So it's another reason. There are also downsides to going to arbitration. One is limited recourse. You may not get everything that you want through arbitration. There could be uneven playing field. In other words, if you have a set of arbitration panel and you have a certain law firms that utilize them, there could be seen as some bias if they constantly utilize the same arbitrators. There is people argue about lack of transparency. Sometimes it's not as open as litigation. But there's also a rising cost too. I mean, it's kind of funny. Our cost is on both sides of the chart, but the cost of arbitration is going up. I can tell you one of the cases that we had involved international arbitration involving Singapore arbitration, and we were defendants. Plaintiff filed a lawsuit. It was a huge amount of money. We thought it was bogus claim. But according to arbitration clause, which they asserted, that it was going to take place in Hawaii, arbitration in Hawaii with 3 arbitrators. So if you can just imagine the cost of moving everybody to Hawaii, kind of like a nice vacation over there and have arbitration. So I don't know if this is by design or otherwise. So the cost, again, the cost of arbitration was a portion of the mountain dispute. So just because it's a bogus, we think is a bogus, complaint, you still have to pay the fees, and it was enormous. So bottom line is we ended up doing mediation, which I will cover a little later, and we settled the case. And then lastly, very important, no injunctive relief. So another thing, again, arbitration is great. Another thing you can't do is, let's say you're ready to go arbitration in about 6 months, and you just find out, and let's say you're the party is seeking payment, and you just find out the other party is moving assets around. Okay, someone's telling you they're moving assets overseas to another country or something like that. There's no quick way to stop them. Okay, you have to wait until arbitration, unlike the courts. So it's this aspect is not available. So if you have that situation, you may have to go into court right away and seek injunctive relief, including temporary restraining order and stuff like that. So that's another thing to keep in mind. Next slide, please. Okay, so we just covered the arbitration clause real fast. Another very important part of contract law in the U.S. is a choice of law clause. So if you're a Korean business doing, dealing with a U.S. entity, you just want to make sure that you feel comfortable about the choice of law that you put in a contract. So choice of law basically says, if there's a dispute, which law will control? Is it going to be Korean law? Is it going to be Texas law? Or is it going to be California law? And you have to be mindful of differences in laws so that you pick the right type of law. Now, you may not have a choice. And I go back, and even arbitration clause and choice of law clause all really depends on how much leverage you have over the other party. Sometimes you get a contract, it's literally take it or leave it. You sign or you don't get the contract because they got to move on to some other buyer. So as long as you have leverage, you have time to think about these issues. And frankly, the best way to kind of protect your rights is to go to an attorney, maybe to Mr. Kim in Korea, if you're a Korean entity doing business with U.S., or local attorneys here in the U.S. about choice of law. Is very important because that can determine how things are decided. And as shown in the slide here, a lot of people choose Delaware as place because that's very friendly to corporations. And stuff like that you'll learn through advice of counsel of how Delaware law is different than Texas law versus California law. Next slide, please. Okay, so we just cover choice of law, which law to apply if there's a dispute. This slide talks about choice of venue, and the venue is simply location. Which location, which court is going to determine the dispute. So venue is very important if you're a Korean company doing business in the US, because not all venues are going to be the same. So venue like Los Angeles, where it's very used to having foreign companies operate, may be different. If you go into other states, maybe not as friendly to a lot of the Korean companies. So you always have to remember which venue you're looking at in terms of if this gets placed in the contract, choice of venue, you should look at the terms very closely because it may determine what the outcome is. Unlike Korea, in the US, we have a jury system, which makes it even worse. People that determine your rights are not going to be people from great law schools or whatnot. They're going to be common people who are not lawyers who's going to decide how much to give to the other party. So it's very important to look at the venue where this may take place. Next slide, please. Okay, attorney's fees clause. So this is when legal disputes happen. This clause says normally I think Mr. Kim had mentioned that our system in the U.S. is each party they're paid on their own attorney fees. That's a general rule. However, there's exception if according to contract. If you say if there's a dispute that arises between the parties, the winning party gets is reasonable attorney's fees paid by the losing party. That's the term, and it has to be reasonable. You can't have somebody charging crazy amount of money just to bill the attorney's fees. Now, I also like to caution a lot of people because people get the wrong idea that just they'll start a lawsuit believing in this. Hey, I'm gonna get my money back through other parties because they have to get attorney's fees. I tell you one thing. Most of the cases get settled in the U.S. Most of the great majority get settled, whether it's before lawsuit, during lawsuit, at mediation, before arbitration, even after trial starts. But one of the first things that you sign off when you settle is to waive attorney's fees. In other words, each party go their separate ways and pay the attorney fee. So be always mindful. I have a lot of clients who talk about where's my attorney fees from the other side. And a lot of times that's going to be waived away. So a lot of times that is not going to be available at the end of the day. So be mindful of that. All right, next slide, please. Okay, indemnity clause. So what this is basically you have a clause in the contract that says the wrongdoer must make the other party, innocent party, a whole. That is, if you do something to me, you got to make me whole. And that's what that's about. The problem with this clause, again, is that indemnity is only worth the financial strength of the other party. You could have all the indemnity clause you want. If they do bad things, they're responsible for everything, including your attorney's fees. Sounds good on paper, but if they're not solvent, then that's not going to be worth anything. So one of the things that you have to think about is think outside the contract between the two parties. And one of the ways to do that is to transfer risk. And basically what the contract is about, when things go sideways, who's liable for the risk? And the risk gets transferred several ways. You can have third party through a standby letter of credit. You can buy credit insurance, or you can go through what's called factor, especially if you're in the shipping business. Shipping goods from Korea to U.S. So there are other ways to kind of mitigate your risk and liability. Next slide, please. And one of the ways is to buy insurance, like I said, a credit insurance. So you look at the risk, look at the whole harmless indemnity agreement, make sure you have the right amount type of insurance coverage. And sometimes people like to even make sure the insurance companies are up to par at certain what's called A.M. Best rating. So you make sure you look at all these things. Next slide, please. Best practice, always typically governing law of arbitration. I say that, more importantly, best practice, I think, is anytime you have a contract relationship with either domestic parties or international parties, you really don't want to have a lawyer take a look, because having somebody look at the contract before they sign is a huge benefit. We get phone calls all the time. Let's say somebody from Korea, they signed a contract and nobody's paying them, right? They ship goods to the U.S., reliance on the contract. What can they do? And the problem is they didn't look at the contract thoroughly, and you have all these issues about choice of law, choice of venue, and all those things that are against you. So you really want to focus on the language of the contract before you start shipping. Next slide, please. So takeaway, always look at the arbitration clause and look at the contract very thoroughly, hopefully with the assistance of counsel. Look at the foreign element I think we talked about. When you are an outsider or from Korea, think about you trying to litigate or settle disputes in certain venues that you're not familiar with. That's something that you want to keep in mind. And then always be familiar with U.S. laws and arbitration institutions, and something that you should study. The last thing I would say, I know we're almost out of time, be careful when you do transactions. And we see this a whole lot. It looks like it's becoming more prevalent because of we're working from home. But one of the things that we see from international transactions is you got people whose emails get hijacked. That is, you have A and B. A is somebody, let's say from Korea. B is another company in the U.S. And there's a transaction, and one of the parties have to pay another party. You have a situation where these days you have somebody will hack into the email exchange, and it's really difficult to tell because the email is off by, let's say, 1 digit. Instead of Scott Lee at Louis Brisbois, they have Scott Lee with 2 L's Lee, and then you don't notice. What happens is they ask you to send money elsewhere, and real big problem arises because at that point you don't know who's responsible. Is it the company that got hacked? Is it their responsibility, or is it the payer who has to pay, might have to pay double? So these are kind of the issues that you should be aware of, especially this COVID-19 era that we live in. So next slide, please. So we'll take questions at the end, but I think I went a little overboard, but I think we're done with our presentation. Thank you.
Thank you for the great presentation. Now I'm going to introduce Soo Jin Isicoff. She is corporate attorney at Brisbois in Fort Lauderdale, Florida, and she specializes in corporate law and commercial law. She will present how to set up U.S. corporation. Good night. Soo Jin.
Hi, everyone. Thank you for the introduction, and I would like to thank KCAB International for hosting this webinar and all other panelists for having me as a speaker. So, steps to set up a US company. So I made 4 simple steps to set up a US company. Step 1 is planning stage. Step 2 is deciding entity type. Step 3 is selecting taxation. And step 4 is drafting company documents and filing with the state. Next slide, please. So step 1, planning stage. So this is when you want to determine what exactly you want to do and where and how you want to do it. For example, company name. So for everyone to have company name, you must check the availability of the company name availability online. For example, to make sure no one else has the same name. Where to incorporate and which state. This can be important because every state has different laws and regulations, which means also different requirements. So you may have to file some documents for one state and the other state may not require the same documents. Do you need a special license to operate your business? Depending on the state's requirements or type of business you operate, you may need a special license or permit. Do you need a visa? Even though a foreigner or non-US resident may incorporate a company or set up a company overseas, if you like to manage a company within the US, you may need a proper working visa. Next slide, please. Step 2 and step 3, selecting entity type and taxation. So this may be the most difficult steps out of all the steps. So I get questions about this all the time, which entity type is the best and how it should be taxed. The answer is it really depends upon you and your business goals and what you like to accomplish with your business. So I made a little chart that compares corporations and LLC to most popular entity types. First, I'll go through the asset protection. So both of these entity types, corporation and LLC, have a great personal liability protection. This means that personal assets are protected from your business liabilities. And business structure. So I think that the biggest reason why people really like an LLC over corporation is because this flexibility of the business structure. So while LLC has very flexible business structure, a corporation is required to elect board members or executives to manage the business. Meanwhile, LLC is flexible in that owners can manage directly without electing any like officers or executives. So non-US owners can establish both entity types within the US. And for corporation, typically it's for a little larger size of the company, while LLC is for smaller size companies. Corporation is recommended if your business is a public company or you intend to go public one day, or if you want to associate yourself with that kind of big business. However, if you want to go public one day with your company, LLC is not recommended. Next slide, please. Step 4, drafting company documents and filing with the state. So documents needed to set up a US corporation are follows. Certificate of incorporation and articles of incorporation is called 법인 인증서, and organizational minutes and bylaws, 조직 회의록 및 부칙, 그리고 shareholders agreement, 주주계약서. For an LLC, that's the equivalent document will be operating agreement, and share certificate, 주식 증명서, and IRS form SS4, that is application for employer identification number, that's 고용주 세물 식별번호. These documents are important in that way that especially shareholders and agreement and operating agreement are where all the protection of the company lays out. So I see my clients all the time going, having a litigation over the language of these types of agreements. So I really recommend you draft this document with consultation with a lawyer or, under the supervision of somebody professional. Next slide, please. So setting up a US company as a non-resident. If you are setting up a US company as a non-resident, there could be potential issues arises, such as income tax issues for non-residents who want to take income out of the US, or obtaining proper US work visa, or opening a bank account for the company because often it requires social security number. Next slide, please. Complying with data and privacy law. So this is one of our common legal issues for Korean and US corporations doing business overseas. Ensuring compliance with GDPR and CCPA, which is the California Consumer Privacy Act, and GDPR, everyone knows, the European Union's General Data Protection Regulations. So next slide, please. So GDPR went into effect on May 25th, 2018. Why GDPR was introduced is because the old law was written before smartphones were around, so collecting all this sensitive information. So GDPR gives organizations and businesses guidelines on what they can and cannot do with personal data. So what is personal data? It is any data they can identify you, including such as your name, phone number, username, or even your IP addresses or your location data. While GDPR is European Union legislation, It can apply to all entities not established in EU. That's why it's important you are always compliant with GDPR. So what happens if you are not in compliance with GDPR? You can get penalties such as fines up to 20 million euros or 4% global gross revenue, whichever is greater. So CCPA. CCPA is California Consumer Privacy Act. It went on effect on January 1st of this year, and it applies to commercial entities in and out of the state with revenue greater than $25 million per year that collect personal information about California residents. The protected data here is information that relates to or is associated with an individual, device, or household. There is also penalties if you are not in compliance. It can be a fine up to $7,500 for each intentional violations or $2,500 for each unintentional violation. So it is also very important that you consult with lawyer or professional that you are in compliance with the CCPA, GDPR type of regulation and law. Next slide, please. Thank you so much. I will take the question now. And if you have any questions, please feel free to email me on my email address shown on the screen. And thank you for having me.
Okay, thank you for the nice presentation. Now I'm going to introduce Evelyn Hahn. She's managing partner at David Hirson and Partners, and she specializes in U.S. immigration law. She represents immigration for Korean expats. Evelyn.
All right, welcome everyone, and thank you for joining us today. My name is Evelyn Hahn. I'm a managing partner at David Hirson and Partners, which is a full-service immigration law firm. It is my absolute pleasure to be here today, and I thank KCAB International and Consulate General of Korea for organizing and hosting this great webinar and inviting me to speak on a panel with my fellow speakers. Today, in the interest of time, I will be mainly covering E2 visas and L1 visa options for Korean expats, and if I have some time left, then I'll briefly discuss other temporary work visas and green card options. So let's get started. Next slide, please. Next slide, please. Please move to the E2 visa slide. Next slide, please. Okay, so what is E2 visa? E2 visa is for an investor from a country that has an E2 treaty with the US. Luckily, South Korea does have an E2 treaty with the US. The investor must have already invested or actively in the process of investing a substantial amount of capital in the US company to actually develop and direct a company. So at least 50% of the US company must be owned by the nationals of the treaty country. For example, here, South Korea. Here, a lot of people think that the E2 visa is only for small business owners who want to open a sandwich store or laundry or dry cleaning business. That is not true. Even a mid-sized or large corporate investors from South Korea or other countries that have E2 treaty can be the E2 investors. Then the next question my clients often ask me is, okay, then Evelyn, how do you define whether that entity, the company client investor, is Korean nationals or not? So for an entity owner, we look at the 50% ownership of the entity and see if they're Korean. If the 50% owner of the US company is not just an entity, but a combination of both entities and individual shareholders, then we look at the nationality of the individual investors, whether they're Korean, and the majority shareholders of those entity owners are Koreans. So we go all the way up until we can confirm that the 50% owner of the US company is Korean nationals. So that's how we measure and determine whether the large conglomerate Korean companies can be an E2 investor. The business had to be a real and operating business and can't just be a marginal business where the US enterprise has present or future capacity to not only break even, but to start generating enough profit to cover all the overhead business costs, operational costs, and the investors' living costs. So all E2 visa holders must have intention to depart the US when E2 status ends or terminated and cannot have intention to immigrate at the time they obtain their E2 visas. Again, when they obtain E2 visas, they cannot have intention to immigrate. While sharing very similar requirements, the main difference between E1, I'm sure you guys heard about E1 and E2, E1 visa and E2 visas is that E1 visa is only for the treaty traders, which carry on substantial trade, meaning over 50% of the volume of international trade must be between the US and the treaty countries such as Korea. So not many companies or traders meet this requirement. So E2 visas are more popular visa options that a lot of people try to obtain than E1. So if you think you may qualify for an E1 and want to discuss further about your situations, please send me an email separately and we'll discuss separately. Next slide, please. So once the E2 entity investor, either individual investor or company investor, meets the qualifications, then they can bring their employees from the overseas office in Korea or other country to their US subsidiary or affiliate offices, provided that their E2 employees are also from the same E2 treaty country. So for example, if the E2 treaty investor is Korean entity, then the E2 employee also has to be Korean before, in order to be able to transfer over to the US subsidiary or affiliate. So there are two types of E2 employees who can be considered for an E2 employee visas. Number one, executive or supervisory employees who will be overseeing the operations and subordinate employees, or employee that has special skills. It's called essential skilled employees who has skills and expertise that is required by the E2 enterprise, such as an engineer or R&D specialist. So one of the most common misconceptions that a lot of people have about E2 visa is that because Korean people use the word 주재원 to refer to both E2 and L1 employee visas, they sometimes think that the 1-year foreign employment must be with the parent company in Korea before they're able to obtain E2 employee visa, which is not correct. So unlike L1, E2 주재원 visa, anyone who is not associated with Korean parent company can also be hired by the E2 parent and transfer over to the new E2 company in the US. Next slide, please. So the main takeaway from this slide, in the interest of time, I'm not going to go over everything in all the slides, but the main takeaway from this slide is that it is very important to note the difference between the physical copy of E2 visa and the authorized stay they obtain when they actually enter the US in E2 visa status. This actually applies to all type of non-immigrant visas. So per reciprocity schedule, Korean investors usually get the 5-year E2 visa. The physical visa is the physical copy that is attached to your passport, and it says E2 visa. So, but it only means that, they now receive the physical, almost like a travel ticket that allows them to carry and travel internationally. It doesn't mean that they can stay in the US for 5 years. Every time E2 applicant, the employees enter the US, they will only given 2 years authorized stay and will get I-94 expiration date that will end after 2 years, which must be extended every 2 years. For E2, it can be extended indefinitely as long as business operates, right? But it has to be extended every 2 years while they have 5-year visa, which allows them to travel, almost like a ticket to travel. So they get an automatic extension of 2 years every time they travel abroad, or they can file an extension petition with US Immigration Agency in the US if they don't want to travel. So because it is so easy to get the automatic 2-year extension just by traveling back and forth, most of the time people do not file a separate application with USCIS, US Immigration. However, because of COVID-19, there are a lot of company employees who do not want to travel to renew their E2, so that they decide to actually prepare the paper application to submit to the US government. So E2 spouse can work. They can obtain work permit. They don't have to work for the E2 company. They can work for any type of third-party companies in the US. And E2 dependent children under 21, minor children, can also attend school and accompany with the principal E2 applicant. Another very common misconception that a lot of people have about E2 is that they think that E2 status cannot be adjusted to this green card program called EB1C, which I will go over very briefly in the next slides, but that's not true. Even if you obtain E2 employee, there is a way to adjust the E2 status to an EB1C green card status that is given to the intra-company transferee executive or manager employee. Next slide, please. So, you know, there has been a recent update in the Immigration Agency Foreign Affairs manuals confirming that E2 visa can be available for businesses with virtual offices. So it's been a recent update. So I think this was in response to COVID-19 maybe, but in my opinion, I think this is only meant for the US business that can be operated remotely from home, not for the business that actually require a physical business space to operate. So US consulates in South Korea have been very particularly stringent and have always applied strict scrutiny on E2 visa applications, especially for startup companies, and have always required them to have physical space, physical premises. So with this change, updated change in the FAM, Foreign Affairs manuals, it will be very interesting to see how flexible the US consulate in South Korea will adjudicate these startup companies' E2 visa applications. Next slide, please. E2 visas are not subject to the latest presidential proclamation 10052, which suspends visa processing for certain visa program. So, you know, we can still apply for E2 visas. However, there's a long wait time. So currently, as of now, E2 visa interviews slots are fully booked until November or December of this year. However, it is still possible to request for an expedited E2 visa interview appointments if there is an urgent need that can be justified on paper, such as COVID-19 related projects that will help reduce the number of COVID-19 cases, or other urgent US, you know, very critical US company projects that will be in, you know, US's national interest, which will create US jobs, you know, boost the US economy. Then, you know, it may be possible to obtain expedited E2 visa interview. Back in April 2020, we were successfully able to obtain expedited interview appointment for our E2 client, even when consulate at the time, because of COVID-19, completely shut down their office. We were successfully able to obtain the expedited interview in 3 days. Next slide, please. So next popular visa options for expats is L1. So first of all, I'm not going to have enough time right now. It's already 6:04. I'm not going to have enough time to talk about L1A blanket visa or L1B visa for employees with specialized knowledge. I'm going to be focusing only on the regular L1 for the small to mid-sized company or large-sized company clients that you will always get, you know, that is more popular than, you know, blanket or L1B specialized knowledge applicants. So for those who want to learn more about other blanket or L1B, please let me know separately. So L1A, next slide, please. So L1A is a non-immigrant. This is also a temporary work visa that enables a US employer to transfer an executive or manager from their foreign company, foreign parent, you know, subsidiary or affiliate company to its new or existing parent, subsidiary, or affiliate company in the US to work in the same level of managerial or executive capacity. So here the L1A employee must have had at least one continuous year of physical employment in South Korea within the last, or other, you know, overseas companies that has affiliation with this, you know, Korean headquarter office within the last 3 years preceding the application for admission into the US. So unlike E2, now you really have to have this at least 1 year physical employment with the, you know, overseas company before being able to transfer over to the US company. Next slide, please. Okay, so the immigration agency officers use a different definition for the manager and executive. So I'm not going to go over the details of the different definitions, but I want to point out that while it used to be okay to explain the particular L1A position, you know, meets both manager and executive definitions by cross-referencing and explaining how they can be both manager and executive, because, you know, it does happen, right? You can be both manager or executive at the same time. As you know, if you read the definition, then you'll see what I'm talking about. However, recently, USCIS began to raise more and more issues and claiming that the person cannot be both manager and executive. So we have to clearly distinguish between the two and select one. Next slide, please. So there's a big difference between new office L1A, startup company in the US, versus existing company in the US. So for the startup company, the L1A, the first L1A, executive or manager employee, the expat, will only get 1 year of authorized stay, versus if the company already has their existing company or acquired the existing company in the US, then their expat will get 3-year authorized stay. And then both startup company, the new office L1 and existing L1 can be extended up to 7 years in increments of 2 years. So for an L1, unlike E2, the company must secure a physical premises. So including office space and the warehouse, if applicable, even before the first L1A, even if it's for startup company, business plan is not enough. They have to, it's almost like a chicken or the egg situation, but you do have to, unfortunately, you do have to secure the physical premises, as well as, if it's warehouse is required, then you have to secure the warehouse before you're able to apply for the L1A petition. There's no required minimum amount of initial capital to be invested, into the U.S. company, but we normally suggest that it should be at least about $250K or more to begin with, but obviously more the better. And for the new startup company L1, a very detailed business plan with clearly and very practical, realistic hiring and financial projections for the next 1 year. 5 year is even better, have to be clearly documented in the business plan. And in terms of hiring and then number of the employees to be hired within 1 year, there's no magic number which will guarantee the approval, but we usually say that the chance of getting an approval is if it's 8 to 10 employees by year 1, end of year 1, then it is very high chance of getting an approval, but it is very aggressive number, 8 to 10 employees by year 1. Not many startup companies can do that, right? So even if it's less than 8 to 10, like even if it's 4 to 5 employees by year 1, end of year 1, it is still okay. It might be still okay as long as we can show that the company is expanding, doing and operating its business according to the business plan. And also we can make an argument that the employee, the expat, is also not only overseeing the US operations and employees, but also the global functions and employees from the Korean parent company or other global offices of the Korean headquarters. Therefore, this person is a true executive or manager. Here, we're not just talking about the manager of all the functional employees or staff. We're talking about the manager of the managers. They have to be the top level manager who manages the managers and professional workers who in turn oversee and supervise other functional level workers. Next slide, please. I'm not gonna go over.
Sorry, we have some technical problems, so Evelyn is gonna do the presentation again. Evelyn?
Okay, so next slide, please. Next slide, please. Next slide. Yeah, so unfortunately, L1 is subject to the latest presidential proclamation 100052, which became effective on June 22nd, 2020. So therefore, as of today, all US consulates have suspended all L1 visa application processing except for the ones that fall under the national interest exemption. So, however, this does not mean that we cannot file L1A petition with US Immigration Agency in the US. We can still file an L1A petition with USCIS in the US. Once it's approved, then it'll be transferred over to the consulate for consular processing. It just means that they won't, process the visa applications except for those cases that fall under the national interest exemption. If the company business operation is essential to the U.S. food supply chain, or such L1A employees' entry would be in the national interest, such as COVID-19 related work or any type of work that will bring substantial benefit to the U.S., then we can still request for the exemption. Next slide, please. So we have successfully obtained national interest exemption approval, and a request for expedited L1A visa interviews were approved in 1 day. Next slide, please. Please move all the way until the chart, E2 versus L1. So a lot of people ask me, this is the most common frequent question that I always get as an immigration attorney, is the difference between E2 visas and L1 visas. So I prepared this chart that lays out all those differences between E2 and L1. So please take a look at and let me know if you have any questions. Next slide, please. Next slide, please. If any of your expats have any extraordinary ability in their field, such as science, engineering, or business, and their work or achievements are nationally or internationally recognized, then they may qualify for a visa called O1, EB1A, or NIW, National Interest Waiver. So, if that's the case, then it might be worth reviewing their credentials to see if they qualify for those visa or green card options. Next slide, please. There are several other recent immigration issues related to COVID-19. So if you have any questions, please feel free to reach out to me. And thank you again for attending our seminars. And it has been my great honor and pleasure. And now I will pass to our host for the closing remarks.
Okay, thank you for the last presentation. Our last presenter finished our presentation. Do you have any questions? No? If you have any questions, send us email or call us. I'm going to follow up with our attendees with additional information from this webinar by email. Thank you, everyone. It was a pleasure being with our panelists and attendees today. Is there any comment before we wrap up here? No? Thank you again for joining us today, and we'll see you next time. Thank you.